Good. Hello. Thanks. Sorry for that. Good afternoon, ladies and gentlemen. My name is. Thanks for being here. I'm going to give a couple of minutes for people to register, and I will start talking a little bit about the organization. Please keep in mind that if you have to leave or if that you get distracted by something, the webinar will be saved, so I can send you the link later just in case you don't want to miss any of the information we're going to show you. So I'm going to start with a brief introduction. As I said, my name is Marcella Scarpellini. I'm an environmental lawyer. I'm currently working at Right Based on Science, and I'm working with climate-related legal risks because I would like to determine if and in what way can science-based sustainability metrics, which is the metrics we at Right Based on Science are generating, can serve as a tool for managing and reducing risks or legal risk for companies. So it's basically at a corporate level. I would also like to remind you that this is an introductory webinar for which we will cover a lot of information, but from a very general perspective. So if you have detailed questions, you can ask for them, but please keep in mind that the scope of the webinar is introductory. So the purpose is for you to start getting an idea of the webinar in regards to climate-related legal risks. I'm going to turn off my camera now, and I'm going to start with the presentation. So you won't be seeing my face for you to be able to focus on the presentation. Just 1 second, please. Yes, so here we are. And now I'm going to start with the presentation. As I said, I'm Marcella Scarpellini, and I'm going to start with a brief introduction of the company for you to be able to know where this webinar comes from and what is the purpose. So Right Based on Science is the company I'm working at currently and the company I'm representing via this webinar. And Right Based on Science is a young company located in Frankfurt, Germany. It was founded in August last year, 2016. And the main goal of the company is to enable transparency around climate-related risks and opportunities at a corporate level, so at a company level. The way in which we do this is by combining climate data and sustainability data and company-specific data, and generating and consulting on science-based sustainability metrics. So we're working with existing metrics, and we're also generating our own metrics. For this purpose, we're 4 employees, and we count with the help and advice of 4 advisors, and we're a very multidisciplinary team. So our team has backgrounds in international business, mathematics, law, and psychology. Now I'm going to show you the agenda for you to have an understanding and a little preview of what we're going to be looking at today. So we're going to start with some context, an explanation of the context. Then we're going to look into the climate-related legal risks derived from such context. And we will end up with science-based sustainability metrics with a brief explanation of what they are. And we're going to explore in what way can these metrics help manage the risks that we talk about today. If I make any pauses, it's because I'm going to drink some water, just for you to have that knowledge. Sorry. And at this point, I would like to say that the webinar will last 45 minutes, and there's going to be 15 minutes for questions. Questions can be voted upon. So if you're reading other people's questions, I cannot read the questions because I'm just looking at the presentation. I will answer the questions that have the most votes. Please write your questions in the Ask the Question box, which is in the middle of the screen and not on the right side of the screen, because it's easier to manage the questions via only one stream. And for all of you that are joining now, as I said, this webinar will be recorded. So if you have to leave, or if you get distracted, or if you want to see it once again, I can send you the link after it's done. So now we're going to start. And we're going to start with context. What is going on? So on the one side, we have a whole community of people discussing about climate change, the future of climate change, how to manage climate change, how to price climate change risks and consequences, how to allocate responsibility for climate change and its consequences. But on the other hand, we have climate change saying, hello, I'm here, and I'm here to stay. And the way in which climate change is making its appearances is that we're seeing increased climate-related costs, we're seeing an increased number of climate litigation, and we're also seeing increased demands for disclosure requirements. So the question is, how do we deal with a problem that we're simultaneously trying to understand? How do we manage? How do we respond appropriately to a topic which is so big and so uncertain, but that demands immediate action? And one of the ways that this response is profiling itself is by the progressive consideration of climate as a financial issue. So currently, today, climate is still treated as a non-financial issue in the form of CSR, corporate social responsibility, communication, marketing, and traditional sustainability strategies. But we believe that with costs arising through climate change in the form of regulation, reputational damages, climate litigation, and operational costs increasing, there's going to be a peak within the next 2 or 3 years in which the costs of financial costs will be so big and so considerate that companies will no longer have the option or the consideration of deciding to choose to regard climate as a financial issue. Now I'm going to show you some examples of how the treatment of climate as a non-financial issue differs when treated or when regarded as a financial issue, just for you to have a little bit of an understanding, just in case you're new to the subject. So when treated as a non-financial issue, so the duty to disclose when treated as a non-financial issue, it's that usually it responds to sustainability strategy and the requirements that disclosing sustainability strategy and sustainability risks do or have in a certain system or according to certain regulation. When treated as a financial issue, it's the same information, but what becomes relevant, what must be reported and disclosed is the impact of such information at a company, so as in a company's cost. So for example, these are just examples, there's much more implications. The increased costs and or reduced demand for products and services which will happen due to the impact of climate on a certain company's performance. As well, the reduced revenue from decreased production capacity due to climate affecting energy, earnings, or different aspects of a company. Another way in which it will differ is the instrument in which it's reported. So when treated as a non-financial issue, it's usually reported in the management report. When treated as a financial issue, it's usually reported in the annual report or in the financial report in the event that they're separated, depending on the company. What also differs is the stringency with which it is treated. It's much more flexible when not treated as a financial issue, but when treated as a financial issue, it has to be able to respond and attend to questions of materiality and fiduciary duty. And last but not least, time scope. So what differs is that when treated as a non-financial issue, it's the backward-looking information what must be reported, so a company's carbon footprint. When treated as a financial issue, on the other hand, it's forward-looking information that becomes relevant. So the carbon handprint. What is the strategy of a certain company to respond to its carbon footprint? That's what becomes relevant. So now, having an understanding of how the treatment of climate as a financial issue may look like, we're going to start to study some of the risks that may derive from this new categorization or from this new treatment to a traditional topic. So what is being discussed is how the impact of climate as a financial issue will have repercussions at a corporate level. And this is where the legal risks derive from. We will look into upcoming regulation, corporate accountability, and litigation as examples of climate-related legal risks. And now we're going to look into upcoming regulation. So upcoming regulation is a traditional risk category in that it might force companies to either adapt or modify performance requirements. It may affect earnings, management, and in general, attempt to modify working and administrative conditions in a company. The reason why I decided to incorporate it as a specific climate-related legal risk is because of the scope and of the amount of upcoming regulation that we're going to see in order to try to curtail climate change or try to respond to climate change. Now I'm going to show you some examples of upcoming regulation. Please bear in mind that this refers exclusively to Germany, so there might be several similarities specifically within European countries, but these laws that I'm showing you are specifically referred to Germany. So types of upcoming regulation that we're going to see are going to be in regards to increased price of greenhouse gas emissions, which regardless of the price are going to have an impact on operational costs. As well, we're expecting energy efficiency requirements to also be more strict. And the effects that these requirements might have is the risk of stranded assets due to the fact that adaptational costs can be quite high, and so some companies may not be able to comply with them. And the requirement per se will also have an effect on increased adaptational costs. And last but not least, report on climate impacts. For you of those that follow EU law and that are aware of EU law, there's the CSR directive, which is the directive that regulates the disclosure of non-financial issues. The directive was modified at the end of last year, and its new requirements are operational this year. But this directive is going to be revised next year, and discussions say that what is being looked at as new benchmarks is the French energy transition law, which specifically asks companies and financial institutions to disclose on the climate-related risks and relatedness of their investments in regard to their affectation to climate. So in this sense, I'm not sure when this is going to happen, but discussions and revisions are going to be done next year. So as you can see, all of these new regulations are also expected in the next couple of years, for which having an eye open is advisable. So now, seeing that the choice of what information is disclosed and its consequences and the consequences of this choice take place at a corporate and at the high corporate level, we're going to look into a new climate-related risk, which is corporate accountability. For this purpose, I would like to present you with an extract of an opinion of Noel Hutley. So Noel Hutley is an Australian lawyer who was commissioned by the CDP and the Futures Business Council to issue an opinion on what he thought would vary in regards to corporate duties and climate-related risks. And he claims that it is likely to be only a matter of time before we see litigation against a director who has either failed to perceive, disclose, or take steps in relation to foreseeable climate-related risk that could be demonstrated to have caused harm to a company. So in this, we would like to present you with a little test. So we know that the duty to perceive, disclose, and take into account are in the core and the heart of the duty of care and diligence expected of a good and prudent businessman. So in making the determination if certain information or certain risk has to be disclosed, there's two questions that can start rolling the ball in order to come up with an answer. So the first question is the risk foreseeable? And is the risk deemed material? If no is the answer, then it does not have to be disclosed. But if yes is the answer, the information has to be considered, disclosed, and taken into account, at the expense of being found liable for failing to do so. The way in which this liability may take place or materialize can be via fines, but also litigation. So this is going to be, of course, corresponding and respective to a specific country's legislation. Exactly. And if litigation is the case, well, then we're going to see some examples of how this might look like. And that's how we're going to go into our last risk category, which is litigation. We have divided litigation into three categories. following the lead of the carbon boomerang report by the 2-degree investing initiative. I will explain the logic of these categories in the next slides, but just for you to know, they're divided into failure to mitigate, failure to adapt, and regulatory compliance. So this is the division that litigation or different types of litigation might fall into. This is for classificatory purposes only. And at this point, I would like to say that I'm not going to go into physical risks, because physical risks are a webinar on its own. The scope of the legal consequences of legal risk is very broad, and I'm not going to look into it at this point in the webinar. And now I'm going to start with a failure to mitigate, what this category consists of. So failure to mitigate is going to be represented by two types of cases. First, citizens and states going against emitters or states claiming compensation for climate damages. This is the case, for example, of RVA, which we will look into after. And we also have citizens and states going against other states, alleging that a certain state has failed to restrict emissions, and this may have the damaging consequences for the people issuing the claim. This is, for example, what happened in the Urgenda case. The logic behind these type of cases is that existing legislation in a certain jurisdiction may be insufficient to protect citizens from climate change, so they will start issuing or going to court and increasing litigation in order to put pressure on governments to start regulating more. So that's the reason, the logic behind these types of cases. Then we're going to go to the other risk category, litigation category, sorry, a failure to adapt. So failure to adequately manage foreseeable financial risks associated with the energy transition. And the failure in this case will derive from the incapacity of regarding climate-related risks as material, which will consequently lead to inappropriate compliance with existing laws that demand that the information provided by companies is enough to allow informed assessments of the company's financial situation. So the backbone, the core of this category is the failure to acknowledge the materiality of climate-related risks. So the failure consists in that if climate is not regarded as material, then the compliance with existing laws that deal with financial and material and fiduciary duty issues will not be able to be complied with. Yes, so that's the logic behind this type of case. Here we're going to see four types of cases for examples that fall within this category, and we're going to see regulatory investigations and claims against corporations and or either their directors who fail to accurately manage, report, or disclose the risks associated with climate change. This is the case that we're going to see with the Commonwealth Bank of Australia. Then we're going to also see cases of investors or beneficiaries claiming or going against corporations or trustees, claiming that they have failed to accurately manage, report, or disclose the risks associated with climate change and the negative or the impact that this has had on their business. This is, for example, the case that we're going to look into with shareholders versus exit. Within this category or class, we're also going to see corporations and investors claiming against professional advisors, and we're also going to see contractual disputes. For these two last, we don't have an example because of And now we're going to go into the last litigation category, which is failure to comply with climate change normative. Here, we're going to see regulatory claims for breaching regulations that are introduced in order to give effect to ET policies, which is the case of Dieselgate. And we're also going to see anti-regulatory claims. So in this case, it's big emitters trying to deter or to impede the creation or the enforcement of regulation that puts ET policies into force. These type of cases are more related with trade law, so we will not go into them either. And now I'm going to show you just an overview of the cases for you to have a little time to read and to identify which elements you think are relevant. The idea, the reason why I'm also showing you this, is for you to be able to identify these elements whilst I'm talking about the cases. And I'm going to give you about 5 seconds to read it. And now, wait, there's a little computer problem. Come on, slide. Okay, so now we're going to start with the cases. Once again, you have the division and the taxonomy of the cases. So failure to mitigate, failure to adapt, and regulatory compliance. And we're going to start with a case of failure to mitigate. And we're going to start with the Urgenda case. At this point, I would like to give an instruction. So when I'm talking about the cases, I'm going to always start at the bottom left. So I'm going to start with the bottom left, which is the plaintiff's argument. Then I'm going to go to the right, which is the defendant's argument, and I'm going to end up at the beginning, so at the title, which is the court's decision, just for you to not get lost. So what happened in this case? In this case, the Urgenda Foundation claimed that the Dutch government was not doing enough to protect its citizens from climate change. The Dutch government agreed with such assessment, but it claimed that since this was a political question, the court could not rule on it. The court saw differently and ruled on the case and decided that the Dutch government must reduce its emissions by 25% by 2020. This claim was based on, of course, information by the IPCC in order to establish the caps, and it was ruled based on Dutch civil law. This case is actually being appealed, but until the appeal is decided, the Dutch government is obliged to abide with the decision. This is a landmark case in the sense that it was the first case, and it's not the only one, but it was the first case in which the Dutch government was tried and actually obliged to set itself more stringent targets based on climate change and protecting its citizens. And I'm not going to say all, but most countries in the world find themselves in the same position. So we think that the likelihood of these cases being replicated is high. There's a similar case taking place now in Belgium. There's also a similar case that took place in, I think it was in Pakistan. And there's also an interesting case of a group of Portuguese children who, with the help, support of lawyers from the GLAN network, have decided to take 43 signatories of the European Convention on Human Rights to court, claiming that their states are not doing enough to protect current and future generations from the effects of climate change. And the reason why I'm bringing this type of cases into this webinar, which is supposed to focus on corporate risks, is because, of course, once states set themselves more stringent caps, that always arise into national regulations, which ends up with citizens and companies having to comply with such targets. So that's where it trickles down. That's why it becomes relevant for companies. Now I'm going to look into another case, which is also failure to mitigate. This case is also quite interesting. So this is the case of Saul Uyas versus RWE. RWE, just in case you're not familiar with it, is one of Germany's biggest utility companies. And once again, I'm going to start here on the bottom left. And in this case, Saul Uyas, which is a Peruvian farmer who is being assisted by a group of German lawyers to make this claim, says that RWE's greenhouse gas emissions are impacting his property in Peru due to melting caps of the glacier that's next to his house, or very close to his house. RWE, which is the defendant, claims that climate is a very complex issue and pinning it down to one company is simply impossible. What's interesting about this case is that it was heard for the first time in a regional court in Germany, in the state of Hessen, sorry. And it was dismissed in first instance, and it used a German civil law in order to be based. The case, the plaintiff used German civil law. As I said, it was dismissed in first instance, but the question that the judge asked himself was the responsibility that big emitters had in regards to liability for loss and damage due to climate change. So he did not get to know the case, he dismissed it, but he asked himself that question, which is quite relevant from a political and from a legal perspective. The case, nonetheless, was appealed, and the case is going to be heard November 13th in the upper court. So if you're interested in this case, just keep your eyes open. So November 13th is in a couple of weeks. And here what's become most relevant, of course, is causation. So if the establishment of causation can be found with RVE's greenhouse gas emissions and their potential damage on the farmer's property, if in fact this can be determined, then it opens a big case for global emitters to protect themselves and to be alert. That's still being discussed. I don't know how it's going to end, but that's the question that's trying to be determined at this point. And for you to have an understanding of the slide, so on one side we have RWE, the German company, and a pretzel, because that represents Germany. And on the other side we have a little farmer, and we also have like an alpaca poncho, because that represents Peru. And what we're trying to illustrate with this case is transboundary damage, which, if you're familiar or maybe familiar or not, is a category within environmental law in which many claims have been made. But due to the nature of this case, it's still being determined if this is in fact a case of transboundary damage, if the causality within green RVE's emissions or not can be claimed to have an impact on the farmer's property. On this slide, you can see the Peruvian farmer, so this is Saul Ullas, and the likelihood of these cases being replicated is high. I want to say at this point that when I claim that the likelihood of replicability is high, I do not mean that the likelihood of the cases being won is high, but the likelihood of the cases being taken to court or similar cases being taken to court is high. The main consequences of this type of cases are reputational, as well in regards to indemnification and penalties. And what might become interesting is the question, once it is resolved, of loss and damage in regards to the responsibility of big emitters towards climate change. And now we're going to look into the second category, And this is the category represented by failure to adapt. So failure to adapt to existing regulation by failing to comply or to understand or to regard climate as a material risk. And we're going to start with the Commonwealth Bank of Australia. And in this case, a couple of shareholders of the bank decided to take the bank to court, claiming that the bank had in fact failed to disclose climate change risks. The Commonwealth Bank of Australia issued its annual report, a couple of months ago, in which it did disclose climate change risks. So the case was dropped. In this case, in this picture, we can see that one of their shareholders giving a press interview. And we also think that the likelihood of applicability of this case is high, especially or specifically because most financial institutions, or a big number of financial institutions, are still failing to report and to act on climate-related legal risks within their operations and also within their reporting requirements. The main consequences of this case are reputational, also regards to indemnities and penalties. So in this case, this did not happen because the case was dismissed, but these types of cases would derive in consequences like this. What is interesting, in this case, was that so much attention was brought to this case that Commonwealth's bank reputation, when it was already a bit damaged, received even more pressure to change, and they were kind of coerced, not forced, but coerced to divest from a couple of coal mining projects they had considered lending money to. So the Carmichael project, they decided not to lend money to after so much attention was brought to the case because of this claim being introduced. We will look into Exxon. Exxon as another case of failure to adapt. So many of you may know that Exxon has been brought to court on several grounds for a long time, or many times. But now we're just going to focus on one of the cases, which is the failure to incorporate climate risks into their evaluation process. But I would like to start just with this slide, which is by one of Exxon's senior scientists, and he claims, or he says, that in the first place, there is general scientific agreement that the most likely manner in which mankind is influencing the global climate is through carbon dioxide release from the burning of fossil fuels. The reason why I'm showing this slide is to show or to comment on the fact that Exxon knew that its operations would affect the climate, which means that it also knew, or should have known, that climate would end up having an effect on its operations. Claiming that Exxon should have actively incorporated climate information within the valuation of its shares, Mr. Ramirez, who is one of Exxon's shareholders, introduced the securities class action, saying that ignoring such material climate risks would result in stranded assets, which would deem inaccurate prices for the shares. So the response of Exxon to this was that they did disclose climate risks, they did incorporate climate information, but they thought that climate information did not affect its assets because the impacts of it were very uncertain and far into the future. The decision of this case is still pending, so the case has been moved to another jurisdiction. But what is relevant here is the question of fiduciary duty. So the fact or the determination of Exxon breaching its fiduciary duty to its investors by failing to regard climate as materially affecting its performance and its assets. So that's the open question, which will probably be determined in court. Here, we also believe that this type of cases is highly replicable, specifically because there's still not an agreed benchmark or regulation indicating what appropriate disclosure and what appropriate incorporation of climate-related legal risks and climate-related information has on a company's performance or assets. How does that incorporation have to look like? So many cases like this are expected. The consequences of these cases are reputational. They're also going to have effects on earnings, and specifically for Exxon, there's lots of regulatory investigations taking place. So this may be even worse than affectations and reputation for companies of Exxon, having regulators and having to give reports on a regular basis of what their operations are doing. And now we're going to look into a last case, which is a case of regulatory compliance. This is the Dieselgate case. Many of you may be familiar or not with this case, but I will tell you about it anyway. But it's quite interesting to see how existing regulations do have a current impact on companies. And in this case, the Environmental Protection Agency of the United States, the EPA, decided to start an investigation against Volkswagen, claiming that it had intentionally programmed diesel engines to activate certain emission controls only during laboratory emission testing. So the claim was that Volkswagen was manipulating its measuring devices in order to misreport the emissions that their cars were having whilst on the road. So whilst whilst the cars were being tested, so in the test phase, they were complying with the law, so the emissions that they were emitting were in compliance with the law, but when used in normal circumstances, they were emitting much more than what the law allowed these cars to do. Faced with this accusation, Volkswagen admitted to what it was doing. It was taken to court. The case was not decided judicially. There was a settlement. The first, or one of the first settlements, was for $2.5 billion for criminal fines, and as well the obligation of submitting itself to monitoring of regulatory compliance for at least 3 years. We also believe that the likelihood of replicability of these types of cases is quite high, specifically because of the many companies might find themselves in positions like this in which they're not going to be able to adapt to legal requirements, either because it's too costly or because they have ignored the relevance or the weight of such regulation, which will mean that they either blatantly incomply with the law or pay big fines for complying with it. The main consequences of these type of cases are also quite interesting. And in this case, personal liability is being decided. So there's the possibility that one of the directors and as well technicians face jail. That has not yet been decided, but it is an open possibility. And the spin-off into the other types of claims was also interested, because lots of investors decided to also go after Volkswagen because of the repercussions, that this scandal had on the shares of Volkswagen. And as well, we know that only within the US, they're going to have to pay around $25 billion within only US and Canada. So, I mean, it's not cheap. Okay, so here you have a slide again for you just to be able to process all of this information. And now I'm going to just give you a very small summary for you to pick up any information that you maybe didn't. So in the first case, we have the Urgenda case, in which the Urgenda Foundation, Dutch civil society, decided to go against the Dutch government, claiming that the Dutch government was not doing enough to protect its citizens from climate change. This case was decided, and the court claimed that, so the court obliged the Dutch government to reduce its emissions by 25% by 2020. This is a case of failure to mitigate, as well as the next case, as well as the case of Saul Uyas going against RWE, claiming that RWE, so that the emissions of RWE are having negative impacts on his property in Peru. This case has not been decided. It was appealed, and the appeal, as I said, will be heard in November 13th. The third case is the case of the Commonwealth Bank, in which a couple of shareholders decided to take the bank to court, claiming that the bank had failed to disclose climate-related risks. The bank did disclose those risks in their annual report, for which the case was dropped. And here we have the Exxon case, in which Mr. Ramirez, one of Exxon's shareholders, introduced a securities class action, saying that because of Exxon failing to incorporate the information it had in regards to evaluating its reserves and failing to declare that it had stranded assets, then Exxon had blatantly inflated the price of its shares. To which Exxon responded, or has responded, that it has no stranded assets due to climate change, for which the price of its shares are correct. There's no inflation of prices. In the last case, the Dieselgate case, in which Volkswagen was accused and found and pleaded guilty of manipulating its measurement devices in order to comply with the law. So basically, they breached the law and were trying to hide it, for which it was found liable. It admitted to guilt, and compensations are still pending. So the total amount of this scandal has yet to be determined. So the monetary or financial impact of this scandal has not yet been determined. And now the question is, what do all of these cases have in common? And what they have in common is damage, whether it be physical damage, financial damage, reputational damage. And what we really want to try to understand now is how can science-based sustainability metrics help to respond, to manage, or to reduce the likelihood of such damage at a corporate level. And that's how we start the next slide. So damage is what I said, what all of these cases have in common. So we know there is a direct correlation between damage and costs. The more costs, so the more destruction, the more expensive it's going to be. For which regulation, for mitigation, but as well for adaptation, it is expected as a way for providing guidelines for behaviors that might have an impact on damage, and also for organizing the consequences of such damage. So in a 2-degree world, damage is expected. So we are counting with the fact that there is going to be damage. But if regulation is weak now, damage can be so much out of control that we're not going to be able to organize it or to respond to it effectively. So weak regulation now means uncontrolled or very, very, very increased likelihood of physical damages, which may reach a peak which we will not be able to organize so effectively, and will of course lead to very, very high financial costs. But on the other side, if regulation for adaptation and mitigation is strict now, we may have a chance to reduce the amount and gravity of damage. And this is as well going to be financially expensive, but it's going to be financially expensive specifically for companies who are going to have to adapt to this strict regulation. We understand that a lot of uncertainty is as well part of this, but in finding ways of responding to climate change, the requirement of incorporating climate information as at the heart of the responses that we're trying to give to the situation is pivotal. So as I said, there's a lot of uncertainty in regards to climate and how it's going to behave, but there are certain things that there is certain information that is certain and that we can act on in order to adapt our responses to. Within that information, we know that 2 degrees is the limit for manageable climate change. In order to limit global warming to 2 degrees, a maximum of 1,000 gigatons can reach the atmosphere. In order to not exceed this budget, the emission intensity of our economy has to be really and radically reduced. And regulation is a key driver to reach this target. So regulation that has an understanding of the context which it's trying to regulate. And in this sense, we open the question for science-based sustainability metrics. So how can science-based sustainability metrics respond to this? And for you to understand first, the answer to that question, I'm going to tell you what science-based sustainability metrics are. So science-based sustainability metrics are metrics that combine climate data and company data in order to measure or to show the relationship between climate performance of an economic activity and the greenhouse gas effect. In knowing this, the company will be, in setting or studying itself according to certain metrics, or in measuring itself with science-based sustainability metrics, a company will be able to determine the appropriate level of contribution towards global warming. And it will also be able to understand the economic, financial, and legal risks and opportunities represented by such contribution. This will become a bit clearer with the next couple of slides. As an example of a science-based sustainability metric, we have the ecstasy, which is our own metric, the metric we're currently working on. And this metric allows companies to measure their contribution towards global warming. It specifically informs the company of the temperature increase the world would face by the end of the century, should all companies be as emission intensive as the company at hand, given the same economic output, which is in regards to its revenue or its contribution to GDP. In order for you to understand this a little bit more, I'm going to show you, for example, RVE's ecstasy. So we have calculated RV's XDC for scope 1 emissions, so for direct emissions. And it's been determined, so we determined that it's 8.8, which means that if all companies were as emission intensive as RVE from now until the end of the century, we would be reaching global temperatures about 8.8 degrees, which means I don't think there's much life left after that. And now the question of how concerns-based sustainability metrics shield companies against climate-related legal risks. How concerns-based sustainability metrics help companies manage such risks. We believe they can in a preventive way, or as well as an argument if in the case that claims arise. So, for example, if a company was faced with allegations, this would be during a trial, but also if that question becomes an open question, if a certain company is failing to mitigate. So first, in calculating its XDC and determining, here's where we're referring to the RV example. So if a company calculates its XDC and the XDC shows a number that is above 2 degrees, and the company takes measures in order to climate-proof its capital expenditure plans, then it's showing that it's not only the will, but effective action towards mitigating, for which the claim would not proceed. In the case of failure to adapt, for example, if a company is calculated its XDC, it becomes familiar with the climate-related risks derived from finding itself in a certain climate pathway. And in reporting and disclosing such information, it could provide it's adapted to existing regulation. So in this case, it could serve as a shield, but also as an argument in court in the case that this was taken to court. And last but not least, a failure to comply. So in having calculated its XDC, a company is able to determine its carbon exposure and respond to it by adapting capital allocation strategies to be able to respond to such regulation. I'm going to give you an example with Dieselgate. So should Volkswagen have calculated its XDC, it could have understood that there was, in fact, coming or existing regulation to which its technology should have adapted to, or should have had to adapt to. In failing to have that technology, it could have redistributed its capital allocation and invested, for example, more in technology in order for them to come up with the technology that would allow them to be able to comply with emission requirements that were being legally demanded. So in this case, we believe that science-based sustainability metrics, specifically the XDC, because that's the metric we're working with, can help companies from preventing claims, but also can help as proof or evidence in the case of trials, for example. And now going back to the initial question, in regards to what to do. So do we wait, do we act? And we believe that this is not an either or question. We do believe that discussions have to continue. We do believe that there's a lot of common agreements to be made, but we also understand that there's a requirement to act now. And seeing that companies or businesses have around 60% that can contribute to climate change by 60% of global emissions, then there is a big chance for business to stir the course of action. And we believe that science-based sustainability metrics, even if still being developed and counting it or based on scientific information, which is also uncertain, can be an initial first step in order to start perfilling a specific answer towards this big and complex topic. And now I would like to open the door for questions, but I would also like to say that if you're interested in calculating the XDC for your company or of a certain company, then please just drop us a line. And as I said at the beginning of the webinar, this is an introductory webinar. So if there's any suggestions or comments or ways in which you would consider that climate-related legal risks could go into, please also drop us a line. We're very open to research and to exploring different questions in the matter. And now we're going to have 15 minutes for questions. Thank you very much. Okay, I'm going to read this first question. So, hi Marcella, I have a question on what you said on the failure to comply with climate change. You said that anti-regulatory actions are dealt with under trade law. Why? Are there not other fields of law that fall under this category, such as liability law? Yes, liability law also falls within this category, but what we're expecting to see a biggest increase on this types of claim is specifically against trade law. So big emitters trying to push regulation either in their states or the states to which they sell their products to, and the negative or the response from that state from accepting certain products. If I have not answered your question, please tell me and I will do another attempt, or I can write to you after. Yes, now we have another question from Sule Omotayo. Hi, Sule. So, because the government isn't really accessible, and when we go to the court, it's always treated with levity. Which other ways can we as individuals solve this problem, especially which ICT waste, where in Nigeria have the most in Africa? Well, specifically in regards to waste, I cannot tell you because I'm not so familiar with this topic. I can ask the people with I work and see if we have a question for waste. But what you can do as an individual, so not waiting for government to give you response, is set yourself a science-based sustainability metric. So set yourself more strict targets than what you're legally obliged to at the moment. Then you're sure to, in the event that stricter regulation comes, then you're safe, and you're also safe against claims. So what you can do now is at a corporate level, try to shield yourself as much as possible, and also try to contribute as much as possible from your perspective from your standing point. Hi, Joanna. Just a clarification. So there's another question. Just a clarification. Sorry if I didn't understand, but are you addressing loss and damage within the failure to mitigate? This is still an open research question for me as well, Joanna. So I'm still looking into this because I really don't still know how to address loss and damage at a corporate level specifically and individually. I don't know if I said this at the beginning, but I have my team here with me, and they're more of the technical experts on the ecstasy. So if you have technical questions, please have a bit of patience. They will answer to them as they can. If not, we will get back to you. So Andrew, I don't know if you can listen to me. I'm gonna read to your question now. So hi, I'm wondering about the calculation of ecstasy in relation to fossil fuel producers. The potential liability against these companies for failure to mitigate are based not only on their own emissions energy intensity, but also on the emissions resulting from the use of their products. RBE is not typical in this regard because it burns most of its own produced coal. Is this end use of product reflected in ecstasy, and could it be? Let me know if this answered your question, please. I have a questions from Alexei Kotko. Is it possible to get links to the more detailed description of and discussion of specifically economic methods of assessment of climate change risks? If there is, I can see if we can, what I can find, and I can send it to you. When calculating the ecstasy, do you correct for the sector, or how do you scale up from the individual companies to all companies? Francisca, yeah, good. Thanks, Hannah. Okay, I don't know if anybody has more questions. Okay, Hannah still responds. Oh, yeah, there's more questions. Okay, sorry. Hello there, I'm a polymer plastics engineering student. Your webinar was very informative. I have a question. Hi, thank you. How can I apply this knowledge in my technical domain, like in business industrial sector, so that climate change will reach as many as possible industries? Well, as I said, this is specifically for companies. So the idea of this webinar and the idea of our company is to address, so treat the problem at a company level. So in making companies aware that there are sustainability metrics that they can measure their performance with is the first step. So if you can make a business and industrial sectors aware that they can in fact measure their climate pathway and their climate contribution based on the 2-degree goal and based on the carbon budget, I think that you would be doing a very, very good service to humanity by starting companies with that. Yes, well, or very, very cleaner put, help reduce companies' emissions at the science stage. So from a business development perspective, at a very initial stage. Is there a way to get resource materials from you on green climate processes to mitigate climate? Well, I think that's available on the web. It's quite easy to find, but yeah, exactly. If you could be more specific, it would help. And how can I apply this? Well, I'm going to set a startup on my own. So the way in which you can apply this is by studying your business model, trying to determine its climate pathway. And we have a project actually called Q2, which is specifically this. So it's a lot of startups that are trying to work with doing this at an initial start level. I can send you some information on that. That can maybe help you. It's not a tool. It's a program which it's an experimental program we were using. It's called Q2, K-O-O-2, and that's exactly what we're doing. Yeah, thank you, Hannah. Is calculating XDC the only applicable method for climate change risks assessment? Yes. So Hannah says that no, but the only science-based as far as we know, just in case for all of you that are not reading. And now I have 1 minute more. If you have any questions, please write it down now. But I would very much thank all of you for coming. As I said, if you're interested in calculating the XDC of your company or for a specific company, just drop us a line. And if you are interested as well in developing the climate-related legal risks in a certain direction, or if you have questions in a certain direction, please let us know. Thank you very much. And as I said, this webinar will be is being recorded, so I can also send it to you. Have a lovely evening and hope to see you in the next webinar. Bye.